Okay, everyone, so now we sort of come to the conclusion of special education and sort of the last phase. So, in the special education world, we've gone through identification of children all the way through forming an IEP, doing the evaluations, uh, implementing the IEP, working through disciplinary issues and manifestation determinations, but sometimes things just break down in the special education process. Now, we have a mechanism in society for when things break down, what to do about it, and we use the courts to deal with that. But we all know the court system is an inefficient system, and when it comes to students with special needs, something being wrapped up in litigation for 2 to 3 years is not fast enough for us to actually continue to meet the best interest of that kid in real time. So, as part of the overall component of special education, the federal government also implemented a separate administrative hearing system to try to speed up the process of making decisions in special education for when things go wrong. Okay? So that's what this is, dispute resolution. You'll hear it referred to many different things from time to time. The due process system it gets referred to as the hearing system. So it gets referred in different ways, but this is the mechanism that we deal with disputes in special education. Okay, so when I say that, what does that mean? Well, actually, even the dispute itself is a multi-step process. From the initial complaint, parents need to be notified of their rights in special education, including the right to file a complaint formally and how they go about doing that. All right, so they file a complaint. Immediately, as we talked about in the discipline module, stay put kicks in. So the stay put provisions lock the child into the current IEP, and they stay in that IEP until the dispute resolution process is completed. All right, the law has now set up several steps prior to the due process hearing. All right, and so first off, the law now mandates an informal meeting on behalf of the parents and the schools. And the school can only bring lawyers to that meeting if the parents bring their lawyers to that meeting. Okay? So what they're trying to do is they're trying to keep the lawyers out of it. Can the adults, the parents and the school administrators and the special ed directors and everyone else just work it out? So first, there's a whole separate meeting just to try to work it out. If that doesn't work, then there is an optional mediation procedure where it's not even really a mini court system yet. It's just a separate outside external entity that comes in and tries to mediate the situation between the family and the school. Okay? So now let's assume mediation has not worked. Now we go to the actual formal due process hearing, which I'll talk about more in a bit. And then if the due process hearing does not work, then we have one final step, and now that step is into the actual court system itself, okay? So the due process system, this administrative system does not preclude cases from going to court, but they first must go through this entire process, which is supposed to take only 45 days from the filing of the complaint. So this is all supposed to happen very quickly for the benefit of the special needs student. Not all of these do resolve within 45 days, but when you're in one of these, you will sense a real urgency in the system to try to get things resolved. Things will move very quickly. Okay, fine. So let's take a deep dive on that due process hearing, and then we'll wrap it up. So that due process hearing itself, right? This is the mini court system, the mini trial that happens inside of the special needs space. All right, these are administrative hearings. They're not judicial hearings, although there is an administrative law judge, and that administrative law judge does sort of serve as a functional judge in that situation, okay? These things are also supposed to be much cheaper. All right, there's entire lawyers that are dedicated to these spaces And they do operate at a more efficient way that keeps the costs down for everyone. There's a bunch of procedures that go with this due process hearing. Here's a few. It must be held within 30 days. Remember, we're trying to go quickly here. All evidence must be disclosed 5 days prior to the hearing, okay? So the law sets this up so that nothing can really be hidden. All the information is supposed to be shared with everyone so everyone knows all the information. The actual hearing functions like a court. You can present evidence, you can call witnesses, they can cross-examine. So it does function like a little mini trial. Then the hearing officer must write the opinion within the following 15 days for a maximum of 45 days from the filing of the initial complaint. All right, so this little mini court hearing has to happen very quickly. The schools must present their evidence. There's, at this point, most likely going to be lawyers involved on both sides, but all the evidence must be presented, and then the administrative law judge writes their opinion. Then that opinion can be appealed to a second level here in Kentucky at the state level, and then that can be appealed to the court system. The due process hearing system, it's unique. There's no other component of education law that functions like this, but it is a really important part of special needs, and as school leaders someday, you all may well find yourself in this situation. Thanks for watching.